This video is about how I met the institutional and program outcomes of paralegal studies in my endeavor to become a law professor of public contract law. At first, I will peruse a fundamental step in this career thrust because such is integral to a career as an attorney and analogous to reaching mastery in any law diligence. Furthermore, these are the important facets to consider as I do this video, those of office management and technology, proficiency of civil litigation in torts and remedies, or in criminal and civil procedures. These same facets flow from understanding the gamut of primary and secondary sources of the law, the checks and balances of government, and our weighted constitution as standard knowledge base to this aptitude. So in this video, I will present how I met both program and institutional outcomes. I will probe the scope of my understanding of law, which I feel forms a legal instinct about producing that pristine legal finish in paralegal diligence, considered suitable to this career and even as a law professor. Now, the range of my understanding goes on trial, for instance, when I begin to describe these basic responsibilities. This program promulgates legal and procedural theories, such as in the limitation in being a paralegal and the crucial importance of it. Accordingly, the bankruptcy attorney in Minnesota was publicly reprimanded for an unprofessional conduct and ordered to pay court fees after repeatedly filing documents the court considered unintelligible because they contain numerous spelling and typographical errors. Additionally, the attorney was required to attend legal writing courses. Quote. Now, this article continues. The judge wrote in his opinion, public confidence in the legal system is shaken, the judge says, when a lawyer's correspondence and legal documents are so filled with these errors that they are virtually incomprehensible. This is the Christie Hall Benson CLA 2007. The significance is in my resolve to work under the auspices of my supervising attorney as a legal agent or paralegal to facilitate him or her with groundbreaking law research and definitive law writing. Now, I can document origination from case law or ascertain the core statute around any issue using Lexis Advance per necessary judicious guidelines of compliance by ethical limitations, those relating to both the supervising attorney and I. This is an example of how I meet those predetermined outcomes in informational literacy and communication, and I am governed accordingly. According to other institutional outcomes, I must go beyond any grapple just to define, to apply, and to defend the principles of legal ethical settings in order that I may comply with the legal ethics and guidelines of reasonableness and censored professionalism by which paralegals and attorneys do serve the public. Rational learning dictates that I facilitate attorneys in what they do well and what they don't do well, and use my employment diversities to draw relevant vigor for further law studies. I am able to use these experiences to create important going forward diligence. Hence, I apply check and balance settings in branches of government, to promulgate the steps to exemplary executive, judicial, and legislative approaches in good law services, and to make robust delivery. This is another way I met these program outcomes of rational learning and critical thinking. Another important enablement that comes from this program as institutional outcomes is the quantitative and scientific reasoning, which I use to induce my basic mathematical skills to analyze and interpret practical real law settings. Here, I qualify information, rather, I quantify information by using discipline or interdisciplinary problem solving to draw workable suppositions. In so doing, I determine financial literacy about billings, retainer accounting, and income tax extrapolations in a law operation. This is important, seasoned, institutional, quantitative, and scientific reasoning. Referring to further diligence of legal terminology and how to distinguish the proper terms and usage in compilation of legal documents, which constitutes express legal correctness, predetermined actions, and workplace categorizations, all of which are of a law operation setting, of logistics, and reproduce law service delivery. It is by emboldened efforts in program and institutional outcomes to design and compose legal documents, as much as legal correspondence, pleadings, briefs, memorandums that pose relevance to substantive facets of law. Examples: statutory has to do with the written will of the legislator by enactment, while common law is a reflective form of the customs of our citizens and a sovereignty. Those were examples. Now, important to this point is how primary sources of the law emanate of government and legislature, as in the materials that by discourse explains, to interpret and to analyze what the law is or it should be, while secondary sources of the law give definitive interpretation and applications of the law. Hence, a paralegal, or as a paralegal, I compose documentation by preset judicious guidelines of standards form rather from primary to secondary sources of the law, inclusive of the local rules and research-driven protocols, and according to the prescribed data from my supervising attorney. Conclusively, to understand that the U.S. Constitution is the core standard of law throughout America is another way I met these program outcomes. In consideration of utilizing electronic and printed resources and how to extrapolate in conjunction with primary and secondary sources of law from related legal documents is to research, summarize, and evaluate about such legal issues. It is clear that the use of electronic print as resources of formatted data of case history are relative references to research, writing, discovery, and all facets of legal discourse rather, in to extrapolate correctly and to efficiently synthesize therefrom. I identify information technology tools, skillful perusal in law-related office practices. How do I do this? By the use of information technology to emanate into better law-related operations. Hence, I met these program outcomes. Finally, the specific matter of interpretation from primary and secondary law sources, as well as to relate such findings on a legal plane by proper paralegal knowledge are needed skillful and requisite behaviors. I'm under the implicit ethical demand that by my critical thinking, I know what I should do, how to decipher and to analyze, to even generate accurate and conclusive extractions of these sources of law. It is by these outcomes that I met the standardizations in what is fundamental to paralegal studies, the in context expectations, and the set of preparations of legal documentation. This is how I engage in critical thinking and quantitative reasoning. To this time, I became a volunteer sports coach in my local YMCA, and I am an associate of the American Bar Association. There are other associations I have on my radio for the immediate future, and I will attend to those as time will allow me to do that. I find community involvement a great augmentation to my career presentation, and all of this is explained in my e-portfolio and my credit account. I continue to foster and will showcase the professional strength of presenting workplace paralegal efficacy, processing from metacognition to critical thinking to research to writing finish for both the supervising attorney and the deserving public. In spite of the daunting work as a paralegal, the succinct of my work is not to let it tether what I do in such a way that it affects what kind of work I produce. I'm resolved, therefore, to get better every turn. I'm E. Barry Batchelor. Thank you.